Well, hello there. This is the Dearborn Essentials of New Jersey Real Estate, 13th edition. We are on Chapter 3. Let me go back to the last slide. Let me talk to you a little bit about this chapter. This chapter is actually my favorite chapter in the entire book because we're going to talk about a lot of real-life practical things. I think that the practical aspect of this chapter is what's really the most important thing that you will get from this chapter. There's a lot of definitions, there's a lot of things that you need to know, but there's a lot of practical stuff. So what I'm really going to do is I don't like the way that to tell you my own story, and I'm going to let myself kind of guide this presentation, and there won't be any change of slides on this. So you're just going to hear my voice. I'm going to kind of talk to you like I would. We were in that classroom setting. So let's talk a little bit about agency, brokerage, ethical considerations, all this kind of jazz. So first and foremost, let's talk about the general law of agency. What is agency when I'm referring to it? Agency is when an agent works on behalf of or represents a principal or client. Okay. So the laws of agency are whenever someone works on behalf of or represents someone else. There's an agent and a principal and or client. Now, there are several different types of agency relationships that can be created. I'm going to explain them to you, and I am going to give you examples of each and every single one of them. So the first one is that of universal agency. Universal agency. So what happens in universal agency is the agent will represent or work on behalf of the client or principal in many different aspects of their life. Okay. The best example of this is power of attorney. Power of attorney. So if I have power of attorney over my grandparents, I would be the agent. My grandparents would be the principal and or client. My grandparents would give me the rights to make medical decisions for them, buy a car on behalf of them. I could sell their house. I could do a lot of different things. It goes into a lot of different aspects of their life. Okay, that is an example of universal agency. The next type of agency is that of general agency. General agency. General agency is when you might control different aspects, but of one particular facet of the principal's life. So best example of this would be a general property manager. Okay, so if I'm working on behalf of John Smith is my client. I manage property 123 Main Street. It's an apartment building. 123 Main Street might have a lot of different things that would come under my purview. I might fix a plumbing problem. I might go and fill a vacancy for one of the units. I may do a lot of different things. It would fall into a lot of different aspects of managing 123 Main Street for John Smith. I am probably not going to lease a car for him. I am probably not going to make medical decisions for him, which would fall under universal agency. Okay. Also, if he had, let's say, another property in another state, another city, and he had another property manager there, I probably wouldn't be falling into the daily basis of, managing that, doing the different aspects of that property management. So general agency would be an example, would be property manager. So general agency would be a property manager. Then the last type of agency relationship that can be created is that of special or specific agency. That would be best described as a real estate agent working in the capacity that they typically work, which means the real estate agent typically will work on behalf of a client to market their home or to help them purchase a home. So if I list the home for a seller and they want me to market their home for sale, I would probably not have the purview to call up a roofer if, let's say, 5 pounds of snow kind of caves in the roof and there's a problem with that. No, they still own the home. That's still their responsibility. Now, they may ask me for names of a roofer, things like that. But I wouldn't be the one picking up the phone and making that phone call and saying, hey, this is something that you need to fix, and then being able to kind of check to them. That's not in my agency relationship with my client. I do not have that purview based on a special agency relationship that I have. So those are the three types of agencies that you can have when you are working with someone in an agency relationship. And as I said, this does go outside of real estate as well. So that's why you have to know and understand the general law of agency. Now, the next thing that we have to do is discuss working with someone. Now we've discussed the different ways that you can work with someone in agency law. Now we have to know, what does it mean to be someone's agent? Okay. So what happens is when you are an agent working on behalf of someone, okay, or representing someone, you owe them what is called the fiduciary responsibilities. The fiduciary responsibilities can be broken down as such. COALD, so cold with an A. Let's go through what each one of them are. You have C, care. You owe the principal a certain amount of care. O, obedience. You owe them obedience as long as the request is lawful. A, this is very important, accounting. Now, everyone always assumes that it is accountability. That is incorrect, because that's kind of like care, okay? Accounting basically means that if you're going to represent someone or you're going to work on behalf of someone, you have to have some basic math skills. 1 and 1 is 2. You need to know certain things in order to actually represent someone, okay? So you can't be someone who has no math knowledge or no accounting skills whatsoever and still think that you could properly assist them, because most things you do have to have some sort of accounting. L, loyalty. You must be loyal. Your loyalty cannot be elsewhere, okay? Your loyalty cannot be elsewhere. And then there's D, disclosure. You must disclose any information that you get as long as it is lawful for you to disclose said information. We're going to get into talking about some of the things that we can and cannot disclose in this chapter as well. So you have care, obedience, accounting, loyalty, and disclosure. Those are what we would call the 5 fiduciary responsibilities that you owe your principal or client. Now, to the other parties in the transaction, you owe them fair dealing. Now, sometimes on the test it will say fair and honest dealing. I don't necessarily think you could be 100% honest all the time. So that's why I always like to say fair dealing, because there might be certain questions that they would ask that you simply cannot disclose to said party, okay? When you're in a contract negotiation, okay, I cannot disclose the ability of my buyers to go up or down, or what their negotiating standpoint is, what their leverage is, okay? I can't use that against them. I cannot go through that with them, all right? But again, it's something that, so in that case, I would not be able to honestly answer someone that question if I owed my client all of the fiduciary responsibilities that we went through, okay? So I could owe them fair dealing, though, and be as truthful as I can be given the loyalty and disclosure issues that I have working for my client, okay? So now let's talk about agency in regards to real estate, okay? Agency in regards to real estate. So let me take you back to a time, let's say before the 80s, all right? Let's talk about how a real estate transaction happens. So a family would get in their car on a Saturday morning. They would drive down to the real estate office over in, let's say, Freehold Township, New Jersey. They go on Route 9. They go to that real estate office with the sign in the ground. They'd go inside and they'd meet Bob Smith. Bob Smith is a real estate agent there. Bob Smith says, come on in, John and Sally. John and Sally come sit down. They have their kid. And Bob says to him, So let's talk about this. You came in here. What can we help you with today? And they're sitting in the conference room. Bob has already set them up with coffee, beverages, got an ice cream cone for the little kid. And they're sitting there saying, well, we want to buy a home in Freehold Township. And Bob says, I have the perfect home for you based on what you're telling me. I think I could get you a good fit. So Bob sits down, gets a binder out, starts asking them questions about their buying capabilities. Has the in-house mortgage rep come over and say, hey, we'll have to get you pre-approved, all this stuff, blah, 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 blah. Bob got John and Sally and the kids in the car, and he says, all right, let's drive and see these homes. Everyone's having a great time. Everyone's opening up. They're telling them about, what they did last weekend, and everyone's trusting everyone, and this is a beautiful, beautiful thing. Now they close. There are no issues, no problems. They negotiated a deal, so I'm fast forwarding along. And they close on the home. Now, the government did a survey in the early 80s, mid 80s, for people who purchased a home and asked them, after a similar situation like that, who did Bob Smith, realtor, work for? Okay. And a large percentage of the people got this incorrect. Large portion of the people said, Bob Smith, the one who gave my kids the ice cream cones and told me how I could negotiate and all these things and helped me find a mortgage, he worked for me. And I would agree that the optics would say that the agency relationship was there. So then now that we have established what agency is, right, we can assume that that also came with knowing the fiduciary responsibility, saying, hey, I'd like to, you owe them care, obedience, accounting, loyalty, disclosure. You owe them all those things. Now, back in the day, at the time frame that I was telling you, in the 70s, that was not the case. It was not the case because buyer agency didn't exist. They worked under the pretense of caveat emptor, buyer beware. The seller, okay, would dictate would basically be the one listing the home. They would be dictating what the buyer's agent commission would be. So he who pays is technically the client. So they followed the money. It was a trail of the money. So technically, Bob Smith might have been a totally different agency. Bob Smith might have worked for Weichert. The listing might have been a Coldwell Banker. Bob Smith was a sub-agent of the seller. So basically, he owed an extension of fair dealing to the buyers, which didn't necessarily mean honest dealing, but he owed all the fiduciary responsibilities, care, obedience, accounting, loyalty, and disclosure to the seller. He was a sub-agent of the seller's agent, okay? So if John and Sally were sitting in Bob Smith's car, and John and Sally told Bob, hey, I can only afford $200,000, and they put in an offer for $195, and Bob knows that they could actually squeeze out a little more money. Well, guess what? He actually has a duty to disclose that to the seller. Now, did this happen all the time? No. But if we got technical, yes, that would be perfectly 100% legal because buyer agency did not exist. Now, year 2018. Buyer agency is now recognized in most states, and it exists, meaning this. There's 4 ways we can work with clients in the state of New Jersey, and they're outlined in a document called the Consumer Information Statement. Now, the 4 ways we can work with people are going to be this. Buyer agent, tenant agent, kind of the same thing, okay? Fiduciary responsibilities are to the buyer or tenant. We owe the other parties in the transaction fair and sometimes honest dealing. Next one would be seller's agent, okay, or landlord's agent. Same thing. We owe them the fiduciary responsibilities, care, obedience, accounting, loyalty, disclosure. Okay. Next one, transaction brokerage. Transaction brokerage. What is a transaction broker? Is it practiced in New Jersey? It's legal in New Jersey. Let's say that. As far as the practicality, is it often practiced? Not often. Transaction brokerage is this. You represent neither party, so neither party is your principal. You work for the deal. You work for the deal. So you only owe everyone fair dealing, okay? So it's kind of like you're a neutral party. The next type of agency relationship we can have in real estate in the state of New Jersey is that of disclosed dual agent. Now, I need to kind of take a step back and make you understand a couple of things. So we understand that there are salespeople at an office. So there's a broker of record, one broker of record. There's a salesperson, and then there's broker salesperson. Now, we have to establish who the actual agency relationship is with. Who's the agent? Who's the client? Okay. So up until now, you've probably thought that the agent who is working with the person is the one who actually has the agency relationship. So they are the agent, designated agent, okay? And then the principal is the client. And that's actually incorrect in a technical standpoint. The agency relationship is actually with the broker of record and the company. And then you, as an individual, are working as a representative of said company. Okay, what does that mean? How does that look? So what happens is this. On the consumer information statement, it will say Stuart Jacobson as a representative of Coldwell Banker, Weichert, Remax, as a representative of, intends to work with you in this capacity. And I will check off a box: buyer's agent, seller's agent, landlord's agent, tenant's agent, transaction broker, dual disclosed. Okay, now dual disclosed. So a lot of people think that dual disclosed agency is when you have the same agent, the same individual represent both the buyer and the seller. That is one of the ways that you can have disclosed dual agency. The second is if you work for the same broker of record. So let's say my friend Scott. My friend Scott works for my company as well. My friend Scott has a buyer for one of my listings. That is dual agency. Now, something about dual agency, I've been saying this, disclosed dual agency. So dual agency must be disclosed, number one. It must be consented to, number two. Okay, you have to have consent in dual agency. You cannot have, okay, dual agency without consent and disclosure, okay? Has to have consent and disclosure. Now, the consumer information statement, I've been talking about this document. I kind of explained to you what it does. It's an informative statement, okay? It tells you all the ways that you can work with someone in New Jersey. It also discusses how you intend to work with them. So basically, most of the time when I'm working with a buyer, I would write buyer's agent and dual disclosed agent if the opportunity arises, okay? And I would probably have them sign a consent to dual agency right there so that I could show them my brokerage's listings as well as my own inventory, okay? This informative statement needs to be given to the client prior to any substantive real estate conversation, okay? This has to be first meeting, okay? It needs to be emailed to them. Why? Why does this need to happen, okay? Here's why. Let's go back to that example where I gave you about Bob Smith and John and Sally, right? John and Sally come into the office. Now, here's what happens. We're in 2018, so let's talk about what happens in that scenario. 2018, in a good situation, John and Sally come into the office and they meet Bob Smith. Bob Smith shakes their hand, says, "Hey, how you doing?" You know, and they say, we'd like to talk to you about, purchasing a home in Freehold Township. So then he says, you know what, come sit down in the conference room. I'll get some stuff and I'll be right back. Okay. Get some coffee, water, all that stuff. And then he says to him, okay, before we go any further, let me give you this. This is the New Jersey Consumer Information Statement. This is important because it outlines how I intend to work with you and who owes you some things called fiduciary responsibilities, which is disclosure, loyalty, obedience, and things like that, okay? So this is how I intend to work with you. So this is how sensitive information that you give me, what will happen if your next thing out of your mouth is I can afford $300,000, because I intend to work with you as this, what does that mean for that information? What does that mean for me as far as advocating for you? So this is a very important thing to understand and to know. And that's why they want to make sure that this is given to the client up front so that they are aware of those things. So that when they get into the car with Bob Smith, that realtor, they know that if they have a conversation that it's going to go a certain way, and that trajectory is going to take them to a place where they're going to have a very happy conversation, and there won't be any kind of implied agency. Let's talk a little bit now. We're going to kind of switch gears. So we talked a lot about the ooey gooey inner workings of, agency. Okay? Now we want to talk about the home. We want to talk about like showing the home and things like that. So one thing that I want to do is I want to talk about latent defects, material defects, stigmas, things like that. Okay. Something that I always love asking in my classroom setting. A little different here talking to a video camera, but I will ask it anyway. Do you think that if there was a murder in a house, that would need to be disclosed to a potential buyer? What about a suicide? What about if it's haunted? It's a haunted house. Now, those things are considered stigmas. They are not material defects in the home. Because they are not material defects in the home, they do not need to be disclosed from a legal standpoint. Now understand this. I have this conversation with a lot of different brokerages, and they say, well, my broker told me to disclose it. Yes, prudent practice. If someone says to you, my house is haunted, prudent business practice would be to disclose, hey, look, the seller said this house is haunted. I don't think that I would feel comfortable not disclosing that. Legally, do you have to? No. Because here's the reason why. Let's think about this. And I'm going to explain this to you in the best way that I could explain it. If I got 100 people into a house of all different backgrounds, all different religions, and I said to them, this house is haunted, would you buy it? There's a percentage of people that would. There's a percentage of people that wouldn't. There's a percentage of people that would be torn. There's a percentage of people that would want an exorcism done, and then they would be able to buy the house. So 100% of the people would not be affected the same way. Now, got the same group of people, same exact socioeconomic backgrounds, religions, all that kind of things. I put a 5-foot hole in the floor, and I said, does that need to be fixed? They would all say yes. The hole in the floor don't need any kind of religion. A working bathroom don't need any kind of ethnic background, all that kind of jazz. So, yeah, it affects people differently. Now, you might be of the standpoint that you don't want to live in a haunted house, and that's absolutely fine. I personally would live with the ghost, and I would have no issues. I know my wife would be completely different. So, again, everyone would be affected differently by this, right? So, that's why there is a difference between having a material defect and having a stigma. Again, we're talking about legal versus business practices. Your broker that you eventually get sponsored by might say to you, no, you don't need to have, you don't need to disclose it because you legally don't. That would be accurate, that you don't legally have to. However, what they might say is that you do have to disclose it. Now, something that I do want to say, because this actually has come up, if the death was caused by some sort of defect in the home, okay, this is interesting, because there was a case in a town in New Jersey where there was 2 children who actually died because of a faulty elevator shaft, okay, faulty elevator shaft. Now, does the death need to be disclosed? No. The death technically doesn't have to be disclosed, but the fact that there was a faulty elevator shaft does need to be disclosed. Okay, so that's the tricky slippery slope. There's a lot of interesting things when you get into defects and what needs to be disclosed and what doesn't. And here's the thing: someone said to me, "Hey, if it was fixed and repaired, does it still need to be disclosed?" I would still disclose it, because that is a material defect that happen with the home. If there is a defect of any sort, I would disclose it, especially one that occurred in a fatality. I definitely would. And you see people get confused because they think that the stigma of the fatality needs to be what's disclosed. No. That's not. I could get more into detail about that particular case. Actually, that was a really great case, but I think that instead of publicly putting this on YouTube, I would rather discuss that offline. So if you ever have any questions about that, you can reach out to me, and I could kind of go into more details. So let's keep going. Another thing that Megan's Law. Megan's Law is something that we track sex offenders with. Now, there's a lot of resources online. I get it. But let's say the internet were to die tomorrow, okay? You would have no resources to find, look up, or see any sex offenders in your area or an area you were looking to move into. Okay. You would have to go to the police department. Now, if you are not a resident of the zip code in which you were inquiring about the sex offenders, you cannot have that information. Now, I know what you're probably saying. That doesn't seem right. But let me tell you what it does and why it was set up the way that it's set up and the problem. Okay? Sex offenders are typically transient individuals. Okay? If all this information was public data to be shared and used in any capacity that we want. Now, like I said, I know there are online resources. I get it. But they're probably not as accurate as if you went down to the police station. Because, again, there is a transience to sex offenders. So what happens is because of the transient nature of them, they only want to disclose sex offenders if there is a potential immediate risk, okay? And they feel that people who are living within the zip code have an immediate risk to know and be aware. However, people looking to move to the town, okay, they feel would potentially impact home values, okay, if there was a transient nature of, you know, let's say next year there was a huge influx into Freehold Township for whatever reason. I don't know why I'm using Freehold all so much, but again, that's something that might change the home values if that was just really out there information, and it would skew and hurt the individuals living in the town. So it's really to protect the innocent on this one in regards to, people who live within a certain zip code, and also to, make aware and have the people who are living within a zip code to know about some immediate threats so that they could take precautions if need be. So that right there is my Chapter 3 10,000-foot view. I think it's a really good view. And I think that you got a lot out of this. So I'm going to wish you the best. If you have any questions, you could always reach out to me, and I'd be more than happy to answer them.